which talks on when you approximately met the first petitioner.
Oh, I've seen it now.
DKG.
Thank you. Yeah, Your Honor, as I mentioned earlier, that was on the day of admission, which we just clarified just now from my handwritten notes of the hospital notes, which was on the 17th of October 2024 at 3:05 p.m.
No, my lord, now the witness is confirming why you are hearing objections. The witness is referring to his handwritten notes, which are not attached to the affidavit.
My apologies, Your Honor. I'll not refer them again.
Okay, please refer to paragraph 4 of your affidavit.
Yes.
And annexure DKG 3.
Yes. Yeah.
That annexure is titled Discharge Summary.
I think you should have somebody to assist the doctor.
Yes.
So that we know exactly what point we are on at.
Yes.
Please not this one then.
And there are timings mentioned in paragraph 4 of your affidavit.
Yep.
And there are timings indicated in the discharge summary. Could you explain indicated in the discharge summary? Could you explain those timings?
This date. And the date of admission, the date of discharge, would that be the issue? Your Honor, this is the day of discharge. The day of admission is the time that the patient was admitted to hospital. As I mentioned earlier, it's written here as 4:18 p.m. I would qualify that, Your Honor, that we must understand what admission date and time.
No, my lord, that's exactly what the law says the witness can't do.
Yes, that one can't do.
I can't explain.
You can,
No, Your Honor, Your Honor,
what you should try to avoid is any interpretation of the document outside the document.
No problem. Admission time 4:18 p.m., 17th October 2024. Discharge 20th November 2024, 1:06 p.m.
Okay, under paragraph 4, there is a timing of 3 p.m. What transpired at that time?
3 p.m. is the time of admission that the patient arrived in the hospital and was duly attended to.
Just a clarification. 3 p.m. and there is the 4:18.
That's what I was going to, and I was stopped from saying, Your Honor.
Please clarify this.
If I'm allowed.
What happened at 3 p.m.? What happened at 4:18?
Exactly, Your Honor. That's the
My
point.
lord, we still retain the objection. It is in black and white in the Evidence Act. If it is in the document, no amount of oral evidence from this witness can be admitted for purposes of adding, subtracting from, clarifying, or all these things is now purporting to.
Your Honor.
Let me rephrase that, Your Honor, and because the times you've read them out, when did you see the patient? What time did you see the patient?
3:25.
As per paragraph 4 of your affidavit.
Yeah.
What time did you see the patient?
Approximately 3 p.m.
Okay. What time was the patient admitted to hospital?
At that time that I talked about.
Which was?
3 p.m. But on the paper here, and you must allow me to clarify, because you have to understand why that date is there, or that time is there. That's why we are here, to explain to you the discrepancy between 3 and 4. Your Honor, if you allow me, I have an answer to that.
Just answer what she asked you, what the counsel asked you.
Yeah. Answer. Proceed.
The discrepancy is because as one comes to hospital, that is not admission. Admission is when the technical details are entered in the admission papers after all other factors have been taken care of. The discharge summary, typing, printing on the computer is done by either the medical officer or the registrar or the intern. In this one, it was done by Dr. Sarita. but the consultant overreads what has been seen there and signs that is correct. So it was prepared by Sarita, signed by me, Dr. Dangekonya.
Okay, thank you very much. Still on page 4 of 4 of DKG3 annexure, which is the district summary. What did you mean by the follow-up that ongoing review, follow-up?
I believe in medical terms, what we mean by follow-up when you are discharged from hospital is that although you have been treated, there are issues that need to be followed up. How are you faring? We actually, at the current hospital, actually call patients at home and ask them, you were discharged last week, madam, how are you faring? But in more than that, we give you an appointment to come back, just to make sure what we did was correct and you are feeling better, and if anything needs to be done, and then most of the time, you actually need almost a lifetime follow-up.
Okay. Is the next term marked DKG3 to your affidavit true and accurate copy of the original discharge summary?
Your Honor, it is.
I'll go to the last bit. During the period the first petitioner was under your care, what communication, if any, did you receive regarding his condition from anyone?
Well, Your Honor, there are always follow-up calls from relatives, parents, and friends. And in this particular case, Your Honor, I must be honest enough to specify that I did receive a call from our president asking about the status of the patient, and it responded accordingly.
What did you communicate in response to that inquiry?
Well, the first time, Your Honor, I just said that we are in the process of doing various tests, and as soon as we have a conclusion, we shall let it known.
Okay.
But if Your Honor, you must allow me to say this, that when I said that, I had to seek clearance from the patient that it was okay so to do, which he gave me permission.
Okay, very well. On my second last question, please refer to paragraph 10 of your affidavit. Paragraph 10 of your affidavit. And annexure DKG4.
Yes, Your Honor.
And tell this honorable court the relevance, if any, of the annexures in relation to your testimony.
You know, Your Honor, during this hospitalization, this hospitalization for reasons that happened that time became a public issue, and there were public notices in newspapers and television services covering the issue.
Okay. Lastly, please refer to paragraph 11 of your affidavit, and in summary, what you'd like this honorable court to understand regarding the first petitioner's admission and treatment.
Your Honor, I have only one statement to make, and that the Honorable Gachagua was admitted to hospital on the date so specified and discharged on the date so specified and treated according to the statutory medical practices.
Thank you very much. That is all, my lord.
Thank you.
Good morning, Dr.
Good morning, sir.
My name is Movomi. I think we know each other.
Lovely. Nice to meet you in these circumstances.
I will ask you a few questions
I'll
on
be pleased to
behalf
answer.
of the respondents
Thank you, sir.
and the second interested party, who is the party I represent in this case. For the record, please confirm that your affidavit is dated 28th of April, the year 2026.
That is correct, Your Honor.
You will agree with me, sir. This affidavit has been made 1.5 years after the events described in it. Correct or incorrect?
My work is easy because I use ClickUp. Here's how AI saves me hours every day. It automatically prioritizes my tasks so I can focus on what's important without wasting time trying to figure out what to do next. I can ask Brain about any list to quickly get up to speed. When I need to draft documents, ClickUp Brain helps me get ideas on paper. And questions in our team channel now get automatically answered by an AI agent with expert company knowledge. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
This affidavit has attached some medical records, Exhibit 3. Correct or incorrect?
Correct.
That exhibit, was it placed before the Senate?
I wouldn't be aware, sir.
You are not aware. But you will confirm whichever date we take from the multiple dates on it. These are again events that this document was available about 1.5 years ago by the date given this of 17th October, isn't it?
I mean, let me search on my report for this. What this is, it's just a yes, that's...
You have to agree this document was available.
Yes.
You also have to agree that with due diligence, this document would have been placed before this honorable court about 1.5 years ago. True or not?
No opinion, sir. I don't know.
No opinion? Fair enough.
Yes.
You have now attempted to explain a discrepancy between paragraph 3 of paragraph 4 of your affidavit. It talks of 3 p.m.
That's correct.
But exhibit 3 at the top right talks of 4:18 p.m.
About an hour difference, yes, sir.
You agree that's a discrepancy on its face? On its face, without more looking at it, is there or is there no discrepancy?
None whatsoever, sir.
Are you saying 4:18 p.m. is the same time as 3 p.m.?
There are different times for different...
There are different times. Therefore, you agree with me, sir.
But could the witness be given the opportunity to complete answers to his questions without being cut short?
Dr. Gikonyo, is it your testimony that the time 3 p.m. given at paragraph 4 of your affidavit is the same time given as 4:18 p.m. in the medical record?
They are different occurrences.
They are different times.
Occurrences. They are not the same thing we are describing.
Okay. This explanation you are now offering on the witness doc, is it given anywhere in your affidavit? The explanation for the discrepancy, is it set out anywhere in your affidavit?
It should be understood.
No, the question is it set out anywhere in your affidavit? That explanation you're now offering in court.
Not there because...
It is not there.
It was never raised. I would have given an answer if it was raised.
We are here to raise it, unfortunately.
And we are given an answer.
Let's stick to that page 104. Dr. Gikonyo, you have to agree with me that we identify individuals in Kenya by reference to their national identity card or passport number, correct or incorrect?
Depends on the purpose, sir. In my class, they call me DK.
Does this document indicate the identity card of the patient being attended to? Does it indicate the identity card number? National identity card number. Either it does or it does not.
We have the client's ID number in
That's
his
not
records.
my question, sir. My question is, on its face, does this document disclose the national identity card of the patient it describes?
Deliberately not.
Good. Does it indicate the travel passport number of the patient?
Deliberately not.
Good. Deliberately not.
Yes.
Very good answer. Does it give the patient's name?
Deliberately not.
Therefore, you have to agree with me, sir. A document that does not contain the patient's name, does not contain the patient's national identity card number, does not indicate the passport number. We have no way, based on the document, of ascertaining who is the patient described in that document.
We do have. We can ask the person who prepared it.
No, the person on the doc is you. Does this document on its face, sir, disclose the identity of the patient described there?
Only by initials, RG.
RG,
Yes.
which could mean anything, isn't it?
To other people, but not to me.
Okay. Fair enough. I put it to you, sir, that you having brought this document to court, you cannot run away from the fact that it doesn't disclose the identity of your patient.
Deliberately so when it was prepared. But now I can disclose. If you ask me who it is, I'll tell you. RG.
RG could as well be Rob Gitau, right?
Could be, but it is not.
It could be Ruth Gitanga.
It is not. Ask me
I
what it
put it
is.
to you, sir, it can be anyone and anything.
In this category, no.
Okay, fair enough.
You can ask me who is RG. I'll tell you who is RG.
The problem, doctor, is we don't believe you. That's why these questions are being asked.
You asked me, why did you write RG? I explained.
It is me who chooses, unfortunately, the questions to ask. So, let's go to that. The title of the document is a medical summary.
Correct?
You have to agree there is a difference between the summary and the primary document.
That is true.
So has the primary document been placed before this court?
I don't know.
Can you see it anywhere in your affidavit? You can take time to flip through.
Not on my affidavit.
It is not in your affidavit. You have to agree with me, therefore, in the absence of the primary document, an independent reader has no way of confirming whether this summary agrees with the primary document.
They can ask the writer who is in front of us here.
No, on the document, sir, we are dealing with the document. In the absence of the primary document, would the third party have a way of confirming whether the summary is accurate?
If that document was adequate in itself, I would not be here. I am here to answer questions pertaining to the document, to say whether it's correct. If it was adequate on itself, you wouldn't call me here.
We actually called you, Dr. Ikonyo, because the document has just too many gaps.
For me
Let's go to the paragraph of your affidavit that talks of the 48 hours to 72 hours.
Correct?
That's paragraph 7 of your affidavit.
Correct, sir.
If that were true, it would mean this patient, and we mean patient RG, whose identity we don't know.
Which I can confirm.
It would mean that this patient would have been discharged on or before 20th October 2024. Correct or incorrect?
Or a month later.
We are following the document, sir. Your paragraph says he was admitted for how long? 48 to 72? Your paragraph 7.
Sir, please read correctly. Recommended.
And when does it say he was discharged?
On the 20th.
Of which month?
Of October.
Of October, good. And what is the discharge date given in the medical summary?
November.
November. That's actually 34 days later.
Correct.
Correct?
Yes.
You have now attempted in your exam in chief to explain the discrepancy.
Not attempting, I did explain.
Okay. Let's take it you have explained. You have explained while on the witness dock.
Yes, Your Honor.
The discrepancy of 34 days, right?
Yes, Your Honor.
Is that explanation set out anywhere in your affidavit? The explanation you gave this court for that discrepancy?
Yes, this is understood.
No, my question is the explanation you are now offering 1.5 years later, is it said, show me the paragraph of your affidavit that explains the discrepancy?
It was not required.
It was not required. But for the record, is it given in your affidavit, that explanation?
Not given because not
Good.
required.
It's not given. This summary gives the consultants who are attending to the patient. Can you see that part of Exhibit 3?
I do, yes.
It begins with yourself. Who are the other doctors?
Your Honor, if you allow me to explain.
You can look at it.
I know it.
I haven't asked the question for you to explain. You can only answer questions I ask.
I know the names on the list, but I can look at them.
The names given there.
Yes, I can look at them, but I know them.
You know them?
All of them, yes.
Is the maker of this document one of the doctors who are indicated as attending to this patient?
No.
No.
Do you need an explanation
So we
for that?
don't have the primary document, and we have a summary made by a person who did not attend to the patient.
Not correct.
Not correct. Is Dr. Sarita, just for the record, indicated as one of the doctors in this summary who are attending to this patient?
She is not a consultant.
My question is she indicated as one of the doctors who are attending to the patient? From the list given at the top, is Dr. Sarita one of them?
Your Honor, I must explain what this list of consultants mean to the audience here.
We are not interested in that. The question is she indicated? Either she is, and Dr. will add quickly if you answer the question. The more we kick about the bush, unfortunately, the longer time it will take.
But I can't allow you, sir, to proceed on a misunderstanding.
My Lord, the witness has no...
Excuse me, Dr.
Yes.
You came here to give evidence.
Yes,
you
Your Honor.
answered questions as put to you by counsel.
Okay.
Without any
But, Your Honor, if you...
deviation. Just answer the questions as put to you. If you don't know, you say you don't know. Then we proceed.
And that's how the law works, Dr. Gikonyo, just for the record.
Thank you. I understand now.
So is Dr. Sarita indicated in this document?
Should you find that there's a need for clarification,
Yes.
they will ask you to clarify.
All right.
Yes.
Go on.
So, Dr. Gikonyo, is Dr. Sarita, the maker of this summary, indicated as one of the physicians that were attending to the patient, known as RG? On the face of it, is she indicated in the list of those doctors?
Not as a consultant.
Is she indicated in any other way?
As a preparing, as the one who prepared the document, yes.
That's not my question. Just wait. Is she indicated as attending to the patient in any medical capacity? The maker of this document.
The people taking care of the patient are not listed.
I thought they are listed here, sir, about 6 of them.
Those are the consultants. There are other doctors in the system, medical officers, intensive care doctors, and other people. And as I mentioned earlier, we are a teaching hospital.
Is there any material you have placed in your affidavit to show those other doctors and the fact that they were attending to the patient?
No.
Good. In fact, on the document before the court, we have no way of knowing Who else other than the 6 given that attended to the patient?
Only by asking the person on the doc.
No, we are talking on the document side.
Not on the document side.
Good. Let's go to the bottom of that document. Bottom left. That document has a computer timestamp at the bottom left, correct? Bottom left, below prepared by Dr. Sarita.
That is right. 2011, 24, 12:40?
12:40 p.m.
Yeah.
So what is the date and time of this document preparation as per that timestamp? It is prepared on the 20th of November 2024 at 12:40 p.m. Correct or incorrect?
Right, that's correct.
Now let's go to the opposite side of the page, bottom right.
Yeah.
What is the date and time given? The date you confirm?
20 November 24, 12:35:19.
12:35. You have to agree those are 2 different timestamps. Correct or incorrect?
That's correct.
You must agree, sir, that it is not possible for this document to have been prepared at 2 different times as it purports to say.
GoDaddy 荣获 hostingadvice.com 评选为小型企业最佳主机服务，归咎于他们的简便。
Unfortunately, sir, you have to agree with me that on the face of it, this is a discrepancy.
Thomas Kimoto Mwingi,
When
John
this document was prepared.
Jerry Maina, David
It has 2
Muni
timelines.
Mulenge,
Which one do we take?
Gichobi Kamoto, Grace Mudomi Mwangi, Clement Mchiri
I do
Muraki,
not know.
Edwin Munene
You
Karioki,
don't know.
Sharia
I won't
Mutandi,
add that it would matter.
na Shadrach Wambuye,
You have testified that this patient,
Father Eddie Waiguru,
that the
Anthony
prior history,
Taga,
we go to page
Victor
204.
Gratia,
Yes, Your Honor.
Asunta Wangui
And you have
Mururi,
summarized it there.
Christine
Yes, Your Honor.
Mukami Njuguna,
Have you
Peter
placed before
Kimani
this court
Joira
any
Alice
primary
Wamuku
documents to
Mbugwa
prove this
Mwangi
alleged prior
Niki Mbugwa
past medical history?
Mbugwa wa Mumbi
Required is
Kigo
available.
Kahari
No,
Priscilla
my question,
Wambui
sir.
Gitari Muchiri
placed
Ngatia
before court
Maria Njeri
Any material
Eric
to show that this patient
Warui Mwaniki Bra-
prior history of
I accept counsel that
None at all.
the
none at all?
parties are
Required, Your
known
Honor. It's
and
available.
can move ahead,
It's available. I have it from
and
here
others
today.
versus the
Unfortunately, it's you
Respondents,
testified on affidavit or note, sir.
Speaker of National Assembly of Kenya,
So
Speaker Senate,
you have to agree with me then
Senate
in the
of
absence
Kenya,
of that material,
Honorable
the
Attorney
record is
General,
just an allegation.
and several others.
We have no way, based on your affidavit, to confirm that the patient
This is the
described there
judgment.
is prior.
Sake of
You have no way, but if you are interested in knowing,
Clarity.
it can be provided.
Doctor, you say you did a number of tests
5, 6.
on this patient,
Yes,
That
Your
is
Honor.
not quite
including an
what I have.
echocardiogram,
Yeah, that is the lead file.
That is the
2D,
Yes.
one is called 12 LED and the other one 2D, right?
Yeah.
This is the judgment.
You must agree
We have
with me
a
that that machine
350
for
judgment,
echocardiogram
page judgment,
generates a report and a graph.
and we'll try
Correct or
as
incorrect?
Of course.
much as possible to read it.
Yes, it does.
Introduction
Have
and
you made
background.
affidavit attached?
In the general
That
election
draft
of
that
9th
the
of August
machine
2022,
generates to show
the
that
first
the
petitioner, hereinafter referred to
As the
as His
conditions
Excellency
described in the
Gachagua,
summary.
was elected as the Deputy President of the
No, it's
Republic
not.
of Kenya alongside
required.
His Excellency William
My question
Ruto,
is, have you attached
whom we refer to as
to the
President.
affidavit
Their election was upheld by the Supreme Court, paving the way for their swearing in on 13th of September 2022,
Definitely not.
beginning what was expected to be a full
Have you
constitutional
attached
term under Article 145, Sub-Article
the
1,
report that the
and
other
Article
machine
148,
automatically
Sub-Article
generates?
6. That expectation, however, was cut short following the successful impeachment proceedings against His Excellency Gachagua. The process leading to his removal commenced on 1st of October 2024, when Honorable Mwengi Mutuse, the 9th respondent and Member of Parliament for Kibwezi West constituency, we shall refer to him as Mutuse, introduced an impeachment motion pursuant to Article 145 and Article 150 of the Constitution.
Would be the primary document evidencing the illness, correct or incorrect?
Correct.
Therefore, if that is correct, you must agree with me
the motion
that this
referred to as
summary in the
impeachment motion
images
cited multiple grounds, including allegations of gross violation of the Constitution, incitement and undermining government policy. The 11 grounds were as follows. Ground 1, gross violation of Article 10, Sub-Article 2A, B, and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and 2B, Article 75, Sub-Article 1C, and Article 129, Sub-Article 2 of the Constitution, and Article 147, Sub-Article 1, as read with Article 131, Sub-Article 2, C, and D of the Constitution. Ground 2, gross violation of Article 147, Sub-Article 1, and 152, Sub-Article 1 of the Constitution by undermining and the Cabinet and effective discharge of the national government's executive mandate. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, Article 189, Sub-Article 1, and the 4th schedule to the Constitution by undermining devolution. 4, gross violation of Article 160, Sub-Article 1 of the Constitution on the institutional and decisional independence of judges. Article 5, Ground 5, gross violation of Article 3, Sub-Article 1 and Article 148, Sub-Article 5A of the Constitution, and fidelity to the oath of office and allegiance. Ground 6, serious reasons to believe that Rigathi Gachagua had committed crimes under Sections 13, subsection 1A, and Section 62 of the National Cohesion and Integration Act. Ground 7, serious reasons to believe that Rigathi Gachagua has committed crimes under Section 45, 46, 47, and 48 of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Money and Anti-Money Laundering Act. Ground 8, serious reasons to believe that Rigathi Gachagua has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Ground 9, gross misconduct under Article 150, Sub-Article 1B of the Constitution by publicly attacking and undermining the work of the National Security Intelligence Service and its officers. Ground 10, gross misconduct or insubordination by openly or publicly insubordinating the President, who is the head of state and government. Ground 11, gross misconduct by persistently bullying state and public officers. The impeachment motion.
The Voto's acne removal, effortless precision with a simple slider. Navigate to blemish removal and select Freckles Acne. Use the sub-slider to seamlessly remove acne from your photos. Experience a 10x faster editing workflow with the Voto for professional photographers. Voto, the most efficient AI photo editor.
Hot 1 petitions with petition number E522 of 2024 designated as the lead file. 5-6, that was cohort 1 petitions. Cohort 2 petitions, where these petitions belong, the lead file is 565 of 2024. On 8th of October 2024, the National Assembly passed the impeachment motion. Subsequently, the resolution was transmitted to the Senate. As the impeachment process unfolded, further applications were seeking conservatory release were filed in the High Court to restrain the Senate from proceeding with impeachment hearings. The Senate thereafter conducted its hearings and upheld 5 of the 11 charges against His Excellency Gachagua, as a result of which he effectively ceased to hold office as Deputy President of the Republic of Kenya. The Senate's decision was communicated to the public through a Gazette notice issued on 17th of October 2024. Following the impeachment, His Excellency President Ruto nominated Professor Kithure Kindiki, the second interested party, whom we shall refer to His Excellency Kindiki, to fill the vacancy in the office of the Deputy President. The National Assembly voted in favor of the nomination, and His Excellency Kindiki was sworn into the office on 1st of November 2024. As the Senate proceedings that culminated in the impeachment of His Excellency Gachagua were underway, and while the National Assembly was concurrently addressing the vacancy created in the office of the Deputy President, further petitions were filed in the High Court at Nairobi and Keregoya, including petition number 565 and several other petitions, being designated with petition number 565 of 2024 being designated as the lead file. Conservatory orders were initially issued restraining the swearing in of His Excellency Kindiki as Deputy President, but those orders were later lifted by this court in its ruling of 31st of October 2024, paving way for the swearing in as earlier stated. Thereafter, the pleadings were amended and cohort 2 petitions proceeded for hearing, culminating in the present judgment. We will now proceed to summarize the parties' pleadings and submissions in the cohort 2 petitions. Summary of pleadings and submissions. Submissions. His Excellency Gachagua is the first petitioner. His case is as follows. He anchored his case on the further amended petition dated 13th of August 2025, supported by his affidavits deposed to on 18th of October 2024 and 27th of October 2024. Speaking to the deficiencies in the process before the National Assembly, His Excellency Gachagua deposed that the impeachment motion lacked the particularization and specificity required under Article 145, Sub-Article 1, and Standing Order Number 64, 1A. He took issue with the lack of credibility in respect of the charges against him in the National Assembly and the Senate. As regards the constitutional imperative of public participation, His Excellency contended that the National Assembly's process was deficient in that the notice was unreasonably short and that it lacked adequate designated venues. It was his case that the exercise was biased, with organizers framing it as meant for invited members of specific parties. He stated that the process utilized unverified feedback forms that resulted in fictitious data. In alleging bias exhibited by the Speaker and Deputy Speaker of the National Assembly, His Excellency deposed that they made partisan statements and also failed to recuse themselves despite having conflict of interest as they were signatories to the coalition agreement that formed a substantial part of the evidence. It was his case that the Senate violated Articles 145, Sub-Article 3 to Sub-Article 6 by skipping the appointment of a special committee to investigate the charges against him, thereby denying him a crucial layer of fair hearing. He stated that Senate imposed an unconstitutional 10-day deadline on the plenary proceedings and unlawfully permitted the National Assembly to introduce new evidence by ambush. He was emphatic that the Senate violated his right to a fair hearing and dignity guaranteed under Article 50 and Article 28, respectively, when he was denied an adjournment. In further support of this position, Dr. Daniel Kibuka Gikonyo, a consultant cardiologist and founder of the current hospital, saw an affidavit on 28th of April 2026 to confirm the medical status of His Excellency Gachagua on the day he was scheduled to defend himself before the Senate. Speaking to the key medical events, it was his evidence that on 17th of October 2024, at approximately 3 p.m., His Excellency Gachagua arrived at current hospital with severe chest pain. He deposed that given his age and underlying risk factors including hypertension, history of diabetes, stress, he conducted ECGs and blood tests and recommended a 48 to 72-hour admission to enable close monitoring, further evaluation, and appropriate medical management. It was his evidence that he supervised His Excellency Gachagua's care until discharge on 20th of October 2024. Far from the impeachment process, His Excellency Gachagua impugned the subsequent nomination and approval of His Excellency Kindiki. He asserted that the process was rushed and there was no public participation despite the dictates of Articles 10 and 118 of the Constitution. It was his case that the clearance from the Independent Electoral Boundaries Commission, or IEBC, was null and void since the commission lacked commissioners, and as such, the Secretariat was legally incompetent to clear the nominee. Further to the foregoing, it was His Excellency Gachagua's position that His Excellency Kindiki was disqualified under Chapter 6 due to gross human rights violation, including abductions, extrajudicial killings during the Finance Bill protest when he served as Interior Cabinet Secretary. Finally, His Excellency Gachagua averred that His Excellency Kindiki was not a member of the UDA party for the requisite 3 months preceding his nomination, and it was his case that the National Assembly unconstitutionally metamorphosed the process into an election rather than an approval under Article 149, Sub-Article 1. For these reasons, His Excellency Gachagua sought the following reliefs: a declaration that the respondents have contravened the provisions of Articles 10 and 18, Sub-Article 1, Articles 10 and Article 118, Sub-Article 1 of the Constitution by initiating a process leading to the removal from office by impeachment against the petitioner without first putting in place adequate legislative and procedural measures for effective public participation. In particular, the Senate's decision was not informed by any input from public engagement. 2, a declaration do issue that the impeachment motion lacks the particularization and specificity required under Articles 145, Sub-Article 1 of the Constitution and Standing Order 64(1)A of the Standing Orders of the National Assembly, and is thus incapable of invoking the jurisdiction of both the National Assembly and the Senate under Articles 145 and Article 150. 3, a declaration that the resolution passed on 18th of October 2024 by the National Assembly purporting to impeach the petitioner pursuant to the provisions of Articles 145 and 150 and the communication dated 8th of October 2024 by the Clerk of the National Assembly to the Clerk of the Senate titled, in quote, Resolution of the National Assembly on a Special Motion on the Removal from Office by Impeachment of His Excellency Gachagua, Deputy President of the Republic of Kenya, close quote, are both founded on a process that is inconsistent and in violation of the Constitution of Kenya and are thus both void and invalid. 4, a declaration that for the purposes of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. 5th, he sought a declaration that the period of 12 days provided under Standing Orders number 64, sub-order 2 and 6 of the Standing Orders of the National Assembly is grossly insufficient time for the National Assembly to facilitate any meaningful and reasonable public participation during the process of impeachment of the President or Deputy President of the Republic of Kenya. Thus, the standing order is unconstitutional insofar as it has the effect of abridging the time for public participation. 6, he sought a declaration that the proceedings before whole house plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited or time-bound to 10 days, as would be if a special committee is appointed under Article 145, Sub-Article 4A. He also sought in 7th prayer a declaration that the petitioner has right to fair administrative action under Article 47, right to fair hearing under Article 50, Sub-Article 1 of the Constitution were violated on account of the petitioner being denied an adjournment occasioned by illness, thus violating his right to appear in person before the Senate of Kenya to be heard and present his case. He also sought a declaration that the National Assembly and the Senate, in their evaluation of the impeachment proceedings before them, failed to properly assess each of the specified grounds and determine if they collectively or individually constitute a gross violation of the Constitution, warranting voting to uphold the impeachment charges against the petitioner. Hence, the resolution of 8th of October 2024 in the National Assembly and the vote upholding the impeachment charges that of the Senate passed on 17th of October 2024 do not meet the threshold for impeachment set out under Article 150 as read with Article 145 of the Constitution. Hence, the same be and are hereby set aside. An order of certiorari to remove into this Honorable Court and quash the decision and or resolution of the National Assembly and the Senate made on 8th of October 2024 and 17th of October 2024 respectively, resolving to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President, Republic of Kenya. At the 9th prayer, the petitioner sought an order of certiorari to bring up into this court to be quashed the resolution of the Senate of Kenya made on 17th of October 2024 to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President, Republic of Kenya, on the grounds expressed in Gazette Notice number 13/400. He also sought at prayer number 11 a declaration does issue that the IEBC could not clear Kithure Kindiki without the involvement or approval of commissioners under Article 88 and Article 250, Sub-Article 1 of the Constitution as read with Section 4 and Section 11A of the IEBC Act. The purported clearance was therefore null and void. Further, the overnight clearance violated Article 10 of the Constitution on openness and transparency. At prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as Cabinet Secretary for the Interior and National Administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 sub-Article 4 and Article 149 sub-Article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1, Article 10, Article 8, Article 118, Article 124, Article 137, Article 148, Article 149, and Article 250 of the Constitution, so that his appointment, clearance, and approval for that position is null and void. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice number 10346 of 2023 for loss of 1, salary, 2, official transport and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office. 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shall be replaceable once every 4 years. 4, 1 4-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers. 12, 2 senior support staff. 13, 2 cooks. 14, 2 gardeners. 15, 2 cleaners. 16, armed security guards, who shall be provided on the request of the first petitioner. 17, diplomatic passport for the first petitioner and his spouse. And 18, office and office equipment. 19, maintenance expense for the vehicles provided. 20, access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may. Through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Ms. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for course determination. 1, whether National Assembly motion met the constitutional threshold under Article 145. 2, whether the Senate violated Articles 145 sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3, whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D, whether there was adequate public participation at both the National Assembly and the Senate. E, whether the speakers of the National Assembly and Senate were biased in reality or in perception. F, whether the overnight clearance and approval of a replacement of Deputy President evidenced a predetermined process. G, whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then, lastly, what are the available reliefs? They collectively, the lawyers for His Excellency, the petitioner, Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned Senior Counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. He submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability. which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145 and Article 150, Council noted that the threshold language, gross violation, gross misconduct, and serious reasons prove impeachment is a mechanism reserved strictly for the gravest constitutional transgressions. To that end, Council drew the support from the cases of Mike Sonko, which we have particulars we have given, Muya and versus Tribunal appointed to investigate the conduct of Justice Martin Muya. We have given citation. He used these cases to argue that grounds must be substantiated by cogent evidence to an intermediate standard higher than a balance of probabilities. Senior Counsel Ngoya further submitted that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Counsel's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Counsel drew support from the decision in Mike Sonko Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondents' invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Chiang Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such. are alleged as such, the judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Ochieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Council concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submissions, His Excellency Gachagua specifically impugned Ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated his inalienable right by proceeding in his absence due to illness, contrary to Article 50, Sub-Article 2F and Article 25C. He drew support from Karaoke versus Attorney General, where it was argued that denying an adjournment impacting a citizen's constitutional rights warrants careful circumspection. He further submitted that the rushed manner of the proceedings mirrored the predetermined and unjust actions condemned in Olo versus Kisumu County Assembly Service Board and another, rendering the resulting decisions absolute nullities. Submitting on public participation and institutional incapacity, it was His Excellency Gachagua's case that both houses entirely failed the threshold. He referred to the decisions in Mohammed and 6 others versus County Assembly of Wajir and other cases which we have stated. To reinstate that engagement must be substantive, one that allows reasonable time and utilizes satisfactory mechanisms. In addition to the foregoing, His Excellency Gachagua, while drawing support from the Decision Independent Electoral and Boundaries Commission vs. Attorney General 2025, discredited the involvement of the IEBC, arguing that constitutional functions requiring commission approval could not be lawfully discharged by the Secretariat without a properly constituted commission. In their rejoinder submissions, the legal team also spoke to procedural illegality in plenary investigation. It was His Excellency Gachagua's submission that the Senate lacked a lawful resolution to appoint a plenary investigation. They submitted that the word may in Article 145, Sub-Article 3B, regarding the appointment of a special committee is a mandatory obligation, relying on a set of authorities, including Sony Holdings versus Registrar of Trademarks and another. They submitted that courts routinely interpret may as mandatory to effectuate legislative intent. Tracing the constitutional drafting history from the Guy and Bomas drafts to the Wako and Harmonized drafts, it was their case that it proved the framers consistently intended for His Excellency Gachagua's right and deter future legislative infringements.
I will proceed from the second petitioner's case, that is Thomas Kimoto Maingi. Thomas Kimoto Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024 before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before retiring in May 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachagua portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. He asserted that the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June, 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submissions. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petitions, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion as, and in public interest, her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that the public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution, and challenged the constitutionality of Standing Order number 64, 2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 1.
From communication to project management to knowledge management in one app, accelerated by the world's most productive AI. 4.0 is the epicenter for all of your work and collaboration. It's the beginning of a new meta-category of apps that will define the next generation of software in the AI age. And it ushers in a new era of craft and quality for ClickUp's product. We've always said that using ClickUp saves you one day every week, but I'm confident that you're going to save a lot more than that with 4.0. Because when all of your work converges into one app, one tab, one AI workspace, everything just clicks.
That was scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024, as ordered by this Honorable Court regarding the special motion, were in disregard of the Court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145(3)(b) of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petition respondents outside the select committee of Senate under Article 145, Subarticle 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 27, 81B, 102, of the Constitution on the 2/3 gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first stated party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, and which she further orally highlighted in court. She identified the following issues for determination. 1, whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B, whether the yes-no templates deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3, whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4, whether the Senate violated Article 145(3)(b) by failing to appoint a special committee of 11 members. 5, whether Standing Order 64-2 prescribing a 12-day impeachment timeline is constitutional. 6, whether the impeachment process